Cheney McBride, who's not present here on the court, but it's the court's understanding that Bill Tanks represents what looks like Mr. McBride. And I tell the Attorney General shall be in touch with Mr. Danks about arraignment. We get him arraigned as soon as possible. All right? Yes, sir. Bob's all right? Okay. Potential trial date, council will agree to December 19, 2016. As far as Mr. Smith is concerned, we'll set a motion hearing date for October 25th. Tuesday. Mr. Wade, I can get you to get Mr. Smith to sign the waiver of arraignment unless he wants to be formally arraigned and all the charges read and all that. They waive formal arraignment. They are pleading not guilty. And we'll set this trial date for that day. There's one other matter on the docket I do want to address. That is, the Attorney General's filed a motion to disqualify Mr. Wade as counsel for Mr. Smith. I'll hear you on that, and I'll give counsel an opportunity to respond.
Yes. Your Honor, our motion is
If y'all can comment before it's very likely at this point, I could.
Sir.
Your Honor, before the court rules on that motion, we need to make a record. Now, Your Honor may not have received no response out of this balance.
I have. I read it.
As I point out in my response, we need to have evidence on this motion, the testimony of Mr. Johnson, because based on the Attorney General's quotes, Mr. Johnson, Adam Johnson, apparently has made a tape of either what Mr. Smith said or what I said about it. And so we believe that my testimony could not be necessary to get that record. And the charge is that Mr. Smith unlawfully talked to me about representing Mr. Butler. Mr. Butler should have evidence about that, about whether Mr. Smith is making any, was authorized to make any statements made about representing. So we need both of those witnesses. Maybe we think they can't, if Your Honor threw me out of the case, they still can't call me as a witness because I just become the attorney liability. I'd like to make a record that every Honor will putting these witnesses on. The Attorney General could proceed to the latest stage of liability that every Honor received to the state Supreme Court. By the same token, Your Honor, when they qualify me, I was sort of going to be. But we want to make make a record with Mr. Johnson and Mr. Butler. I don't think they're on the same line as I.
All right.
our position on that, Your Honor, is with regard to the disqualification of Mr. Wade, the issue is what testimony he would have. And the representation that we have made in our motion is that we intend to call him as a witness in this trial. Now, he's raised the issue of the tapes, as he said. We will be making the discovery, providing discovery to Mr. Wade on behalf of Mr. Smith. It will include the recorded conversations that are excerpted in our motion. And the conversations make specific reference to Mr. Wade and include a conversation with Mr. Wade on one of the tapes that we produced and discovered. More importantly, though, whatever Mr. Wade's position is regarding whether there's some attorney-client privilege, our decision about who we call as a witness is the state's decision. And if he is alleging some privileged conversation or some advice of counsel, the state is further entitled to know the circumstances surrounding Mr. Smith's alleged retainer or consultation with Jim Wade to represent him, and the subject matters that they discuss and the disclosures that Robert Smith made in order to obtain advice, if he did, on behalf of himself from Jim Wade. He's alleging that there's some privilege and that Mr. Smith, as part of his defense, will rely on attorney-client privilege and advice of counsel. We're entitled to delve into that as well. The simple matter at this point regarding disqualification, under Rule 3.7, as we read it, it's a pretty straightforward proposition. If a lawyer is to be a witness in a case, he he should not be counsel. He should not be an advocate. We put the jury in the position of seeing a lawyer operating in two roles. One at counsel table as an advocate, and then secondly in the witness box as a witness. And I'm representing to the court, we will call him, whether we have to call him as an adverse witness, whether he takes a stand and refuses to answer the questions, that would be a matter for your honor to take up the trial. But we do intend to call Jim Wade as a witness in this criminal trial.
Let me ask you this, counsel, Mr. Anderson. Is it premature right now to make a determination on your motion? By that I mean this. If for some unforeseen reason you determine later that you're not going to call Mr. Wade, and I were to order that Mr. Wade be removed as counsel for Mr. Smith now, would not that impinge upon Mr. Smith's right to hire whoever attorney he wants to hire to defend him on a felony charge? I know you stand to talk to the court before you now say you intend to subpoena Mr. Wade as a material witness.
Correct.
Right?
We do, yes, Your Honor.
That's an intention of a future act 3 months from now. Right? What's your position about your motion being premature?
Well, two concerns I have about that, Your Honor. If the court defers ruling on it, Mr. Wade has participated up to the point of, say, the motion hearing, or even as far as the trial date, and then, Your Honor, is brought with that motion again, there's going to be an issue of waiver, and Mr. Smith's argument, I'm sure, will be that at that point that Mr. Wade has been involved up to this point, that has been excluded early on to give him an opportunity to hire another lawyer. I understand the law is clear that a defendant has the right to counsel of his choice, but the rules of professional conduct that control attorneys' conduct in this courtroom make it very plain that an advocate cannot also advocate in a case in which he will be a witness. And if Your Honor wants us to issue a subpoena today, we can do that. I'm telling the court, absolutely, we can't put this case on without putting Jim Wade on the witness stand. We can do that.
All right, Mr. Wade, any response?
Hey, Your Honor, I think this is absolutely 100% bad faith motion. Obviously, because whatever information I have, they have a tape recording of it, according to them, according to their motion. And secondly, Your Honor, if the Attorney General can do this, he can take any case where there's a criminal defendant and says, obviously, any attorney has knowledge. And he says, I want to call this attorney and get into the circumstances under which it arose. Any case I ever represented, I have knowledge about from the client. But my testimony is absolutely privileged. All he called me,
Hold on a minute, Mr. Wade. At the time at issue, the conversation apparently was stated. Who were you representing at that moment in time?
Nobody except Mr. Smith. Only Mr. Smith called me to see
There were any charges against Mr. Smith at that time, were there?
No, there doesn't have to be. He calls me for legal advice. That's the test, John, whether it's a question of legal advice.
Legal advice for him or legal advice for Mr. Butler?
Legal advice for him, obviously, Your Honor, because he's not authorized to speak to Mr. Butler. He's calling me to seek legal advice. The fact that it concerns Mr. Butler is no significance.
Okay.
Not only that, Your Honor, let me suggest this. If he's right about this, if he's right that it's a crime for the district attorney to call me, to ask me or any other attorney to represent a criminal defendant, if that's true, then also take the Fifth Amendment because I've been participating in a crime. So not only can he not call me because of the attorney-client privilege, he can't call me because of the Fifth Amendment. And for him to say, I am Mr. Smith, Your Honor, they think I'm a terrible lawyer. Apparently, I don't think counsel thinks I'm a terrible lawyer. He wouldn't file this motion. But this is a tactic by the Attorney General's office. Your Honor, I may say, and if we ever have a hearing on this, I'll bring the file. They also filed this same thing against an innocence project to try to keep an innocence project from representing capital defendants. I was present when, here's something I do have about that, I was present when Jim Hood threatened a criminal defense lawyer with criminal prosecution, claiming we were threatening witnesses. This is an intimidation tactic by Jim Hood, I suspect not by these fellows, but by Jim Hood. And there is absolutely no basis. They can't call a witness whom they know testimony privilege, you can't answer questions. The United States Supreme Court spoke to this issue on a case I cited in my response. But to just try to strip Mr. Smith wants me to be his attorney, and I'm the attorney of his choice, and that is his constitutional right.
Mr. Wade, have you intellectually thought about what's in your client's best interest if the court were to rule that you were prohibited from representing Mr. Smith because you were a material witness in a controversy, i.e. have you thought about co-counsel or some other attorney who, if necessary at the last minute, if you were disqualified, that the co-counsel could adequately and competently represent Mr. Smith?
Well, let me just tell you this, Your Honor. I have lots of attorneys that call Mr. Smith asking me to represent him, a lot of competent attorneys, and as of today, I've told Mr. Smith he needs co-counsel regardless. As of today, as I understand, he didn't squeak and agree in a form of appearance, but I expect he will soon. So there will be other counsel.
I do not have a crystal ball. I cannot predict where this is going. I'm just saying that it's hypothetically possible that you might have a serious ethical conflict in continuing representation of Mr. Smith. Maybe you do, maybe you don't. I'm thinking a prophylactic measure may well be that he has co-counsel in case that eventuality materialized and you were not able to represent him at trial. Because I understand the next motion would be a continuance for him to go get another lawyer in 3 more months of potential delay to get ready for a trial. I'm just trying to think out loud.
Your Honor, as I say, the way it's worked, I believe Dennis will be in an appearance regardless. I think it may be other attorneys, but I do feel like I'm Mr. Smith's choice of counsel, and I feel like he's entitled to have me represented under the United States Supreme Court case. And I don't see how Your Honor can disqualify an attorney knowing that I might have to take the privilege. Your Honor said, I'm ordering you to answer these questions. I can't violate the attorney-client privilege. You call me for legal advice. And it doesn't depend on there being a pending case. That's true. Anytime any client shows up in my office and tells me about some problem he has, if I don't take the case, then I go out and reveal the conversation. That can't be right. So this motion is not a violation of faith.
I guess the bottom line of this is we need to get a date. I mean, if October the 25th is a date to hear the motion to exclude Mr. Wade, and we hear it, you summons whatever witnesses you want to subpoena here. Factual witnesses.
I might mention, I've got a formal motion with the court, but we don't really want Mr. Johnson, we don't know where Mr. Johnson is. I'm hoping the Attorney General furnishes an address where we're concerned. Mr. Butler, we understand, is in jail, so I'll send it for a habeas corpus and testified order. But the official record is they don't know where he is. So the last time I heard he was in Rankin County, Madison County. I may have asked for some relief in the court to try to get him there. That's all I'm saying.
Well, we'll deal with that. That's a problem. All right, I think not making a ruling on your motion to exclude Mr. Wade is appropriate at the present time. And Mr. Anderson, if you'll just schedule that on October 25th for our motion day hearing. We'll take it up at that time. All right, anything, I need your waiver, signed waiver of arraignment, and your signature on it, Mr. Wade, when you get the clerk to be filed.
No, this was right. I want to make sure this is a good thing. Motion. This is not some tactic on the part of the Attorney General's office. And one other thing I would suggest to the court that we will be doing by way of supplementing this motion, he's going to be getting the case and discovery. I think for your Honor's benefit, we'll provide copies of the tape conversations about which this motion relates to the court for your review as well.
All right. I'll review it. Well, you'll give me a work for a trial date and motion here, is that correct?
This has got a place for
case number would be doing it on. All right, Council, anything